This is TLV1.
The Tel Aviv Review.
Hello and welcome to the Tel Aviv Review, a program dedicated to the word, to the thought and to debate, brought to you by the Van Lee of Jerusalem Institute, which promotes humanistic, democratic and liberal values in the social discourse in Israel. I am Gilad Halpern.
And I'm Dahlia Shendlin. I'm your co-host together with Gilad, and we'll be talking every week about books and ideas and research and other things that have caught our attention. Our guest today is a professor of law at Tel Aviv University. He contributes frequently to Haaretz newspaper on legal affairs, and he's a visiting reader at SOAS University of London. His latest book, The Writing on the Wall, Rethinking the International Law of Occupation, has just been published in English by Cambridge University Press. Professor Aeyal Gross, hello and welcome to the show.
Good morning.
Good morning. So, interestingly, the term occupation, it's very, very present. Everybody knows this term now. This is no longer something people forget about in the international discourse. You say this is a 21st century development. Still, the more it's known, the more it seems to have ambivalent meaning in the Israeli-Palestinian context. Some people even deny it. There was a whole report that was denying that there is an occupation a few years ago. How do you define occupation?
Generally, occupation in international law is defined when a territory is held by another state, which is not the sovereign state, to whom that territory belongs in an internationally recognized way. So basically, territory can be occupied if it's part of the territory of another state, but sometimes you can occupy the whole territory of another state, like when Iraq occupied Kuwait, for example. So the question of how to define is actually a complicated one, and that's part of what the book deals with, because part of what the book argues is that we see changing forms of control, both politically and with changes in technology. So actually part of the purpose of the book is to think in a little bit more flexible way about the definition of occupation and think that there could be different ways where you exercise control over a territory which is beyond your recognized boundaries, which is not the traditional way that we used to think about it, which is having an army fully present, what they used to call, or they still call, boots on the ground. So whereas occupation is generally defined, again, as having actually the authority of the control over a territory shifted from the state to which it belongs to another state, and I will in a minute complicate that even more, I think that we have to think about the changing ways of control, but also of the different cases of occupation where there is more than one of those cases.
We're going to talk about that.
Okay. Yeah.
But I also want to ask you, so basically you're defining it as a state which controls a territory that is not part of its sovereign territory, but that territory it controls doesn't actually have to be a state of its own, correct?
Exactly. So, we can think about cases where you occupy another state, again, like Iraq occupies Kuwait, then US and the UK occupy Iraq, or when you occupy part of another state, not necessarily the whole state. But then we are very familiar in the Israeli-Palestinian context with the occupation of a territory that was never an independent state. Now, this argument was used by some Israelis to say there hasn't been an occupation because there wasn't any other state before. But this position has been rejected by International Court of Justice and most international lawyers. And actually, it's not unique to the Israel situation, because consider, for example, Western Sahara, which is considered by many to be occupied by Morocco. And again, it was never an independent state. So actually, there is, I would say, a distinct category of cases where territories that actually in the process of decolonization never got independent, but instead someone else went in and controlled them. And that would be the case, for example, in Western Sahara, in the occupied Palestinian territory. And you can say that was the case in East Timor until Indonesia ended its control.
I have one more question about the definition here. So to what extent does the definition of occupation include military law, martial law governing the people of that territory? And I'm thinking here of a state which occupied its own sovereign territory, and that's Serbia and Kosovo between 1991 and 1999. So I'm curious to know how you define that, and if it's correct to include that definition of military law governing the people.
Not necessarily, because actually you can say that in a territory you occupy, control should be temporary and is done usually through the occupying army. But you can think of cases where a country unilaterally annexes the territory. and doesn't control it through the military anymore, such as Western Sahara, but then also the Golan Heights.
Crimea.
Crimea, or the Golan Heights in Israel. And so actually, if you annex a territory that you occupied on a unilateral basis, that would be illegal, and you may treat it as if it was part of your own territory and not run it through the military, but that would not mean it's no longer occupied.
So the Golan Heights is still occupied.
Yeah, so is it all the same kind of occupation? And another definition that I found very interesting that you make in your book is that, the different degrees of illegality, that not every occupation is illegal and illegal in the same way.
Well, yeah, part of what argument I tried to make, and this built on some work I've done with some colleagues before, was that we face the problem that a lot of people say, for example, today in the Israeli-Palestinian context, we should no longer talk of occupation. Of course, this can come from two sides. One side which would say, this is a territory that belongs to Israel, to the Jewish people, all those Zionist arguments.
And you can't occupy your own country.
Yeah, it's not occupied, it's liberated. But I'm not talking about those arguments now. I'm talking arguments from the other side, which say occupation is supposed to be this temporary regime where you occupy territory for a relatively short period of time. But actually here there is a long-term occupation where Israel established settlements in the territory. It has its own citizens residing in the territory. It uses the natural resources of the territory, the water and the land. So it's
quarries.
more like, the quarries. So it's more like colonialism or apartheid. So some people say we should no longer talk about occupation. And when we talk about occupation, that actually in a way legitimizes under this idea that occupation is supposed to be temporary, something which is more like colonialism or apartheid. Now, I try to take a little bit of a different stand and say, first of all, why choose? You can have elements of different regimes. And the way I think about law generally is what we call anti-conceptualist. I don't think we have to fit everything into one concept and then draw a conclusion from that. I think we have to think in a way, in the reverse way, and we have to think. So I say there are elements from all three regimes, but I don't think we should give up the occupation paradigm. And in a minute I'll answer your legality question, but this precedes that. Because, for example, people today who say we should not talk about occupation, only about apartheid, and I know it's a very big debate about apartheid, but let's for a moment leave aside the debate whether it's right and legitimate to describe the situation in the West Bank as apartheid or not.
Oh, we're going to talk about that later.
Okay. But for a moment...
but whether it's occupation or not.
But if they say we just want to talk about apartheid, not occupation, then you don't have anymore the prohibition on settlements. Then what you require is equality for everyone, which you can justify. But for example, I think that you lose the idea that occupied people, in that case the Palestinians, are what's called international law protected persons, which have special rights, that you cannot put settlements that will take the land, etc. Now, going back to your question, so I think that what we should talk about is an occupation, but one that derives from the basic principles of the law of occupation, and thus is illegal. So because occupation normally should not give the occupier sovereignty, it doesn't give you sovereignty in the territory occupied. It's only supposed to be a temporary rule, and you have to control it and manage a territory for the benefit of the local population. So if you violate those ideas that it doesn't give you sovereignty, it's not temporary, etc., the occupation becomes illegal, and that's part of the argument.
Is it really the temporality here the key parameter to what constitutes occupation? Because I think part of the reason that in our case, in the Israeli-Palestinian case, that we've moved on from talking about occupation per se, those who have been talking about the occupation, not denying it, is that it is clearly less and less temporary, at least not as we thought before. Is that really the way to look at it?
It's definitely, I think they go together. The idea that occupation doesn't give you sovereignty in territory you occupy goes together with the idea it's supposed to be temporary, right? Because otherwise it doesn't become part of your territory. You only control it on a temporary basis. So they really go hand in hand together. And it definitely is a key. And that's a big difference between what used to be called the right of conquest, that if you occupy territory, you can make it part of your own territory and you acquire sovereignty in it. So definitely, and I think people who say it's no longer the occupation perceived in international law because it's not temporary, it has elements of annexation like putting your own residents or citizens in settlements, etc. are totally right, but I would say to them, it's an occupation where you violated the norms of occupation, so it becomes an illegal occupation.
Can you tell us about what you call the factual understanding of occupation and your argument for a normative approach? Why do you argue for this shift? What do those mean, and why do you argue for this shift?
So this exactly goes to the point of what I said now, because some people say, that was, I think, the traditional position of a lot of international lawyers, that occupation is a factual situation, and because there was a war, you occupied some territory. And you can talk about the legality of certain actions within it. Is it legal or not legal to demolish homes? Is it legal or not legal to deport people? But you cannot talk about the legality of occupation because the law does not prohibit occupation during wartime. And it's just a factual situation. Part of what I've tried to argue, and again, this follows on already some previous works I've done with some colleagues, is that it's also a normative concept. And if you derogate from the basic principles of the occupation regime, which are, as we mentioned, that it doesn't give you sovereignty, it's temporary, and you have to manage it for the benefit of the local population, then you can say that the occupation itself is illegal. And I think that this normative approach is required because if we don't take it, if we take this kind of traditional factual approach, saying occupation is just a factual situation, you can only address the legality of certain action within it, then you have this really big risk that under the title occupation, you will legitimize something akin to colonialism or apartheid or conquest, regimes that should be considered illegal. So
it's interesting that you point out that what made it into a factual concept before was that during wartime, these things happen and countries occupy briefly. I think in the Israeli mentality, many people, certainly in the leadership, but also among the public, view Israel as constantly at war. Do you think that stands behind this perception of those who would continue looking at the occupation as simply a factual necessity?
Yes. I think that's a very good point. And we hear, and that's part of so that's part of a set of reversals between the temporary and the indefinite. So things that are supposed to be temporary become indefinite. The state of emergency in Israel, the state of war, the occupation, the interim arrangement under the Oslo Accords, right? The Palestinian Authority, which is supposed to be a temporary. So the temporary becomes indefinite.
Yeah. We used to say about Israel that there's nothing more permanent than a temporary fact. Now tell us about what you've also argued for in the book, which is a functional approach. What does that mean and why is it important?
So that's really something that I thought a lot about after the Gaza disengagement, because then
in 2005, just to remind our listeners.
2005, when Israel pulled its permanent military presence and settlements from Gaza. And then there started a big debate, is Israel still occupying Gaza or not? And the debate became very polarized. And a lot of people said Israel is no longer occupying Gaza because the army is no longer there on a permanent basis. There is no, again, boots on the ground, as they call it. And I thought, and I'm actually on the board of an NGO called Gisha, which deals a lot with freedom of movement from Palestinians from Gaza, and also through the works with the NGO, I saw that too, that the big extent of control that Israel still has over the lives of Palestinians from Gaza, through controlling most of the borders, the waterways, the airspace, the electricity, and a lot of population registry, a lot of things. And then on the other hand, the other view said Israel still occupies Gaza because of all the control it exercises over so many things, even if it is control from outside most of the time.
Or what the UN report after Protective Edge, the war in 2014, termed effective control. Isn't that what they called it?
Well, effective control is a complicated term. That would normally be required for occupation. But the question is, what do you need to decide there is effective control? So, but then I think that the people who said Israel is still occupying Gaza, I mean, I definitely sympathize more with that position than the opposite. But I think that they also sometimes did not give full account to the implication of the statement. Because, for example, if you're an occupier, you have rights and duties. For example, you have the duty to restore civilian order and make sure civilian life takes place, etc. The occupation would have the duty upon Israel to actually now make sure that schools are running Gaza properly. To when there were hostilities between Fatah and Hamas, the Israeli army would have to go in and intervene to restore civilian order. Now, is that what we think should be legally required? And then my thought was that actually we have to distinguish between which functions Israel does have control over in Gaza and other places, and which function it does not have control over. An occupation is not an all-or-nothing game. So, for example, the daily run of school in Gaza and whether kids make it to school, or the hostilities between Fatah and Hamas, Israel maybe doesn't have control over them, but it does have control over which goods and people enter and exit Gaza, and then in a way that affects education. So maybe, for example, it has the responsibility of an occupier to education or to healthcare as far as its policies and actions affect that, but not when they don't. So the idea was that actually we have to, again, this has to do with moving from the idea that there's a traditional boots-on-the-ground occupation or there's nothing.
So it seems to me as if occupation is almost synonymous with any sort of asymmetrical conflict. One powerful country meddling in the affairs of a less powerful country. If it doesn't really have to be any kind of, undermining the sovereignty necessarily, physically, then where are the contours of occupation then?
I think it's a very good question, and we can think about the continuum of different forms of control here, and maybe that's for the next book. But I think that still you need to have this requirement. I think that the occupying country prevents the exercise of self-determination and of sovereignty. So if you cannot, so Israeli case with Gaza, it's very easy. You cannot control your, waterways, airspace, population registry, who goes in and out, etc. So that would be not just meddling in the affairs of another country by all sort of influence, but actually preventing that country in exercising, its own self-determination and actually becoming even an independent state. But I think we can think about more like when we think in a more flexible way of control, we should think about it more as a continuum. That's true. But I also want to emphasize that we should, I think, be careful that this functional approach should not be used to absolve responsibility. The whole idea was to create more responsibility, to make sure that even if you don't have boots on the ground, but you, in different function of the local population, prevent it from exercising its own sovereignty, you should have the responsibility of occupier, and not just the responsibility of a neighbor, a belligerent, etc.
Okay, so now I want to go back to what you said earlier about the caring for the local population. If you look at one of the case studies that you explore in your book, Northern Cyprus, I'm sure Dalia will have a lot to say about that too,
Always.
because it's part of her expertise as well. But when you have some sort of kinship between the local population and the occupying country, as in the case of Cyprus with the Turkish Cypriots and Turkey, which is the occupying country in this sense, does it really change anything? Because it is, in this case, you can argue more convincingly that the occupation is there to care for the local population rather than the American occupation of Iraq or the Israeli occupation
Although
of
I will
Palestine.
say that the interesting distinction there is the fact of having a Turkish military occupation in the north has made many Turkish Cypriots rather skeptical of this presence. The relationship itself has generated tensions between the local population and the occupying power.
Even more interesting then.
Very interesting, very interesting. I think it would be only one element, because I think that if we think about the situation of Northern Cyprus, then we have to remember that there were Greek Cypriots who were displaced from Northern Cyprus, and they're still battling for at least their property rights there, with some success in the European Court of Human Rights, and then with some less success, and we can talk about that. So there is a question of dispossession there too. Now, it's true that it's different than the Israeli situation in the sense that the government, there is a... So again, we have got very complicated questions. There is a government which is supposedly called Turkish Republic of Northern Cyprus, which the international community does not recognize and says it's actually occupied by Turkey. Now, there's a complicated question about the relationship, as Dalia said, between the Turkish Cypriots and the Turkish government. But even beyond that, even if we say there is some national or ethnic identification between those two groups, which is different than Israel vis-a-vis the Palestinians in the West Bank, it would still not undermine, again, the fact that there was dispossession involved, and also the fact that there is a violation here, even if it brings up other questions, of a basic principle of post-World War II international law, that use of force cannot be used to actually to take land. And in this case, the Republic of Cyprus says, actually, land was taken from me unilaterally by use of force. So that would contravene the prohibition on use of force.
But I think this raises another very interesting point for comparison, which is actually your point about occupation being something that not only extends to a territory that is not part of your sovereign territory, but prevents that other territory from exercising its own sovereignty and self-determination. And in the case of Cyprus, in a way similar to the case in Gaza, you have more than one power that is preventing sovereignty in northern Cyprus, if they were ever actually in a direction of sovereignty. You have the Republic of Cyprus, which does not want the north to be sovereign, and you have the Turkish army presence, which does not really want them to be sovereign and seems to be angling a little bit more for annexation. In Gaza, it's true that you have Israel one could say, effectively occupying on the perimeter. But inside, you also have Hamas authorities who also have control. I mean, I don't know if that's an occupation, but the point is you have multiple powers that are responsible for what's going on there. I mean, what do we learn from these situations?
Absolutely, and you also have Egypt, which is at one of the borders of Gaza. I think that's exactly, by the way, why I think the functional approach may be helpful, I hope, because it says that responsibility can be divided according to the function exercised by different factors. So I don't think Hamas is, you'd call it occupying power.
Right, because they did win elections after all.
Yeah, but also
and
because
they're also local.
Yeah, it's complicated. But I think that you can talk about. So think about East Berlin, think about West Berlin. Actually, Berlin was occupied formally until the end of the Cold War and the fall of the Berlin Wall. It was still so. But however, more and more the function.
West Berlin was.
And East Berlin, actually. Berlin was considered an occupied territory formally until the end of the Cold War. I actually have only.
Who was the sovereign there?
Who was the occupying power?
Yeah.
The occupying power were the Allies. Basically, I have a short paragraph on it in the book. Originally, I had a longer part, but I had to cut it because the book is quite long as it is.
It's a book about everything.
Yeah,
actually.
so maybe I have to write a separate article about it, but it's really interesting because but then there was a gradual transformation of functions from the occupying powers to the German government and then to one German government. But the real occupation ended only after the fall of the Berlin Wall, etc., formally. So actually, you can see different powers have had fulfill different function. And in the case of Berlin, obviously, de facto, most of the responsibility passed to the local governments, and then they should bear the responsibility and no longer, the Americans or the Soviets, whoever was the original occupiers, even if on paper they are. But this was a gradual process. Now, so you can have different.
Actually, that just made me think about another, example that is closer to home, and that is Jerusalem. What is really the status of Jerusalem here? Because according to the UN partition plan, which is, I think, the last binding international resolution on that, Jerusalem was supposed to be a corpus separatum, right? It wasn't supposed to be under anyone's sovereignty. Can we claim, at least theoretically, that West Jerusalem is occupied by Israel?
And I just want to point out for our listeners that you have this look on your face of total despair that you're ever going to be able to explain all this in a short interview.
More than despair.
No, I just think Jerusalem requires really a separate book.
Right.
I have to say, I pretty much, except for some casual references, I pretty much bracketed Jerusalem for the book because I figured it regards its own book.
It's a corpus separatum.
It's a corpus
legally.
separatum. Absolutely, yes. Well, I think that it's an interesting question, but I think generally the accepted position is that whatever was decided in 1947, because remember, we also can ask about not just about Jerusalem, but other territories which Israel acquired in 1948, 1949. Mm-hmm. So whatever was...
parts of the Galilee.
Yeah, at some process, and that's a really very interesting question, but at some process, the 49 armistice borders became Israel's internationally recognized borders, including West Jerusalem, even though it's more complicated because we know the embassies are not even in West Jerusalem, right? And anything beyond that became considered occupied, seized by war in 1967, including East Jerusalem. So I would say, the kind of accepted position is that East Jerusalem is occupied, West Jerusalem is not. And East Jerusalem, like the Golan Heights, is occupied territory, which was unilaterally de facto annexed by Israel. And annexation was not recognized by most of the international community.
Right. The whole thing starts to unravel. I want to go back to, I think you've made a very strong case here for a sort of non-binary approach for defining what occupation is. And I want to quote a very eloquent passage in the introduction where you say occupation, the word, should be included in the category that Cohen, you referred to somebody else, calls, quote, magic solving words, meaning words actually incapable of solving anything if we remain within the binary on-off framework of the traditional international law of occupation. I think this is an approach that is helpful because you talk about a continuum. We don't have to say whether it is or isn't. And this reminds me of a big discussion that's been going on actually just recently all the time, over the term, the A word, apartheid, specifically after a New York Times op-ed on this recently. Proper disclosure, I've written a response to it. Should we be looking at this as a binary question, or is it splitting hairs? We say the situation is legally, morally, historically, and politically problematic. Does it really matter if we give it a binary definition of apartheid, on or off?
Yeah, so a good question. And I think that also with apartheid analogy, we have to distinguish between a political analogy and between the legal determination that the Israeli regime in the West Bank falls into the definition of the International Convention Against Apartheid, or the definition of apartheid in the statute of the International Criminal Court. So some people have done this kind of legal work and tried to determine whether it fits into those definitions, legal definition or not. And some people just use it as a political argument to say there is a regime based on separation between people based on their ethnicity, with different laws applying to them and different territories where they may reside or not reside. But as you say, the binary thing here maybe is only helpful to an extent, or maybe not so helpful. And in any political comparison, we will have similarities and things which are not similar. Partly people used to want to use the word apartheid because apartheid was condemned universally and justified the boycott of South Africa. So I think the political use of it would be, this has to be condemned universally and justify boycott.
No, but in terms of analysis, do you think that it is useful to take an ideal type of thought and try and compare reality to it?
I think we always do that, and it's fine to do it, and I think you have to think what's the use of it. I think you can see a lot of things in the West Bank which are very similar to apartheid, and where I can see why the analogy will be made, and now I'm talking more about even the political stand rather than going to a literal analysis of the legal definition. But I think that it's a question, and I'm just asking the question. I mean, is it sometimes that we want to use a harsher word because we think other words are not strong enough? So think, for example, of genocide. I think the word genocide, unlike apartheid where we can have a debate, I think legally the word genocide is not relevant. But I know people like to use it because they think, that's considered the worst thing, so we want to shout louder.
But at a certain point, words lose their shock value too, especially when they're supposed to have shock value and then they're overused. Those are the ones most vulnerable to being emptied of meaning at a certain point, don't you think?
Absolutely. But I also think that, for example, with the genocide thing, you actually miss the real nature of the Israeli control, which is a long-term control. Of course, it has a lot of violence and a lot of killings, but typified by not killing most of the population. Quite the opposite. So actually, you will miss the real analysis of the nature of this control if you will just want to use the genocide thing in order to shout stronger. So I think that we have to think about, and then in a way also, if you want to say, I want to say genocide, because if I will just say war crimes, a crime against humanity, that's not bad enough. You also say, war crimes are crimes against humanity. That's not so bad, apparently. We must shout genocide to be heard. So I think we have to be careful of just thinking we have to use a louder word in order to be heard. I think, again, with apartheid, it has a specific context of the boycott justification, which is why we hear it.
Mm-hmm. I want to ask you about another term that you use, and we'll have to end on this. You talk about the sui generis nature of this conflict, yes or no. And to what extent do you think this conflict really does represent something that is irreducible or, in other words, unique in the international system today? At least let's just talk about today.
Well, I'm very careful with this sui generis because I think that today, regarding Gaza, Israel says it's a sui generis situation because an occupation ended, in Israel's opinion, but there is no independent Palestinian state. But look, after 1967, Israel said it's sui generis because we control it, but it's not really occupied because it didn't belong to anyone else. And I think this sui generization allows for kind of a pick and choose regime because you say nothing really applies to it exactly because it's a sui generis situation. And as we've talked before, we have other situations where a territory is occupied without there being an independent state before, like Western Sahara. We have other situations of long-term occupation with settlers, like, again, Western Sahara or Northern Cyprus. So, of course, I think every conflict is sui generis and every situation is sui generis. And by calling this sui generis and repeatedly calling it a sui generis, it just used to actually try to say the norms don't apply to us.
Exactly. In other words, saying it's complicated is usually an excuse not to make moral decisions.
Yeah, actually, I can think of other conflicts where that's happened too, and we don't have time to talk about them, but I completely agree with you that the conflicts don't have to be identical for them to have valuable elements of comparison.
All right. Yeah. Okay, Professor Aeyal Gross, Professor of Law at Tel Aviv University and visiting reader at SOAS University of London. The author of the recently published The Writing on the Wall, Rethinking the International Law of Occupation. Thank you very much for joining us today.
Thanks for having me.
And also a big thanks to Tammy Goldenberg, our sound engineer, and to the Van Leer Institute for their generous support. If you like this podcast, there are many more where it came from. Just go to www.tlv1.fm/podcasts and take your pick. Don't forget to visit our new website, telavivreview.org. Like us on Facebook and follow us both on Twitter. We'll be taking a short break for Passover, returning on the 28th of April. Make sure you join us. Until then, goodbye.